Welcome to MCLE This Week. I am your host, program attorney Bruce Richard. For this month's podcast, our guest is John Fields of Fields Dennis Wellesley. John, why don't you tell us a little bit about yourself and your practice?
Thanks, Bruce, for having me on this podcast. I think it's a great idea. I'm an attorney, as you say, in Fields and Dennis in Wellesley. We have a 15 attorney firm where I practiced exclusively in domestic relations law. I do about half my practice in like mediation, conciliation, that sort of thing, and then the rest is kind of litigation and traditional representation and that kind of thing. Been practicing, I guess, over 30 years, and you know, been working with you and MCLE for a long time on various programs. This is the latest one, and yeah, I'd love to talk to you about it.
Sure. So what drew you into family law?
Family law, I kind of fell into family law. I was doing some labor and employment law in New York for a while, and then kind of wanted to do something different. So my wife and I ended up moving in the mid '90s to Boston, and kind of got into family law, and I don't know, I ended up liking it, and I don't know, I kind of fell into it, and I don't know, ended up ultimately finding my niche, which is a good balance for me anyway, between sort of having a mediation practice and kind of a litigation, traditional representation
Right.
practice that sort of suits me, at least personally. So I've enjoyed it ever since I found that balance. So
Nice. So our podcast this month is When 50-50 Doesn't Cut It, Equity versus Equality in Divorce. So John, let's dive in. Let's start with the big picture. So what does equitable division mean under mass law, and how does it differ from a 50-50 split?
yeah, so in in Massachusetts we deal with the courts are empowered to obviously decide ultimately the property division between spouses, and the general principles around property division really have to do with equity, which is sort of that fancy English common law word for fairness, and it isn't equality. There isn't a principle of equality such that property has to be divided equally at all. So one of the things, and maybe this might be your next question, but one of the things that interested me when I kind of thought about this program, and I think I called you some years ago, I
Right.
thought that, why don't we, I thought the following. I thought that, most lawyers end up, including myself, end up kind of looking at these cases and dividing much of the marital estate in an equal manner. Not in every case, certainly, but it's often our starting point. And I sort of started to wonder, in what cases shouldn't we be doing that, and should we be sort of diving into these issues a little more carefully, and looking at certain aspects of property division differently, such that we're not automatically dividing everything 50-50, and we're kind of looking at the bigger picture. And I thought I hadn't seen anyway a program that really dealt with that. And so I thought it would be interesting, and I think it is interesting to sort of figure out in what areas of the law should we really be looking more closely, and figuring out, well, it doesn't really make sense to divide this 50-50 because of maybe there's a trust, maybe there's inherited assets, that sort of thing. So that's kind of what drew me to this program, and I think
Okay.
it's been successful.
So is it mostly just due to assets coming into the
Yeah, I
marriage, or
mean,
are we talking about?
yeah, sure. One place where we certainly are not looking. One place that I think is pretty standard. But we do look at premarital we do look at premarital assets and inherited and gifted assets with, closely. The too complex to go into in this brief
Mhm.
time, but essentially when we see those, we're going to look at those obviously carefully, as I said, and figure out if under the case law, we really should be counting those with all the other marital assets, or we should be looking at them differently. I mean, in Massachusetts, many, if not all assets in a marriage, not all assets, but most assets in a marriage end up being potentially divisible, unlike in other states. Which have more clear notions of separate property. We don't really have that here, so it's up to the creativity of the lawyer or the lawyers to figure out what ought to be perhaps excluded from such division. Yes, and so inherited assets are one of the first things that we look at, like when did it come in to the marriage? Has it been mixed in with other assets? Has the couple relied on it? How big is the inherited asset relative to the other, assets in the marriage? And one of the biggest is it a really long-term marriage? And with the idea that the longer the term of the marriage, the more the stronger the argument that the non-inheriting spouse may have to the benefit of some of those assets. So those are things that
Right.
we do look at as lawyers.
Advance your practice with the MCLE Online Pass. For one monthly subscription fee, you can access everything MCLE has online: live and on demand webcasts, ebooks, forms, checklists, and more. Start your free trial today at mcle.org/onlinepass.
Why do you think so many divorce cases still end with a standard 50-50 division? Is it just
You
we're
know,
simply trained to just find it that way, or?
yeah, I mean it's a great question. I mean, other than inherited, gifted, and premarital assets, which we do, as I say, look at differently. Many times we're not looking at other. We're not really considering the 208, all of the 208-34 factors, and the primary factor in 208-34, which is our equitable division statute, is really there's a bunch of factors in there. Too many to go over. Length of marriage is one, and health of the parties, lifestyle, which we call station. But one of the bigger ones, in fact, one of the biggest ones, is the respective sort of non-economic and economic contributions of the parties. And that really should be what drives the division of assets. Very often, probably as a means of just settling a case, because it's hard for many spouses, many clients to agree to something less than 50-50, because no one wants to think they're less than. We end up at a 50-50 place, but it certainly doesn't have to be that way. And so, yes, I think most cases end up that way. Well, sometimes that's the right. Very often that is the right
Mhm.
result. I won't say that it shouldn't be, but I mean there are factors such as, for example, dissipation of assets, for example. You know, when we should be looking at, what would the date of division of assets be if there was a long-term separation? Are there times when we should be looking at, when these folks separated? Those sorts of things. Even though the presumption is that on that latter part, usually we're looking at the kind of the date of the trial, or the present date. There are times when we should be looking at an earlier date of division, which would probably yield a non-equal. a non-equal division of assets. There are times when someone has dissipated assets, created marital waste, that justifies maybe a disparate division. We'll talk about in the seminar, or
Yeah.
I guess we'll talk about that in detail about dissipation. Dissipation is tricky, and sometimes it's overused. There are lots of rules around dissipation. It's not just because someone spent money in an unwise way that we're going to get a unequal division. But it's definitely something to be looked at carefully. Even conduct, which usually doesn't merit an unequal division by itself, to the extent conduct causes economic harm in some way. That's something that in rarer cases ought also to be considered.
Okay.
I just was one more that I
Yeah.
thought of, which is, under the Alimony Reform Act, um, there's something to be thought of, and I'm not sure we think about this enough, with the durational limits on the it's not new, 2012, I think, but the newer, I'm showing my age, the newer Alimony Reform Act. There are durational limits. So, where alimony is presumed, let's say, to either stop at at 80% of the length of a longer term marriage, or alternatively stop at the age of at the Social Security retirement age of the person, who of the payor, which for people, it's a moving target, but as we sit here today, for people born in 1960 or later, is 67. The presumption is that even if the person continues to earn money, that alimony disappears. So there is something in the Alimony Reform Act which suggests that the termination of alimony could itself be a factor uh, in creating maybe it could be a factor when we think of a property division. So even that, in some cases, could justify maybe a disparate division, and that's something that we don't often see. I don't know how often a court would actually do that, or when it comes into play, but there's something to be considered even there. So another thing, I'll just run with it until you tell me to shut up. No, it's good. I'm just kidding. One more thing that we sort of think about is, we've talked a little bit, we've touched on inherited and gifted assets, premarital assets. Those are things in hand. They are sort of in our wallets and purses, so to speak, or trust assets, which are less in our hand and wallets and purses, but are actual assets. There's something else, we in this field call expectancy interests, which are, if my parents may right now have a will, where they might, unless they get mad at me before they pass, they might leave me money, but I have no legal right to that money. Um,
Mhm.
so that's not an asset for me, but that would fall under the opportunity for future acquisition of assets, which is one of those factors in 34, section 34. And to what extent should something like that change the division of assets? The problem, of course, there is that you're dealing with an uncertainty, and to what extent should that uncertainty change the division of certain assets, or assets that are there with
Right.
certainty. So that's another thing we talk about. We'll talk about that a lot. I haven't seen that often is persuasive to judges. In other words, someone expects but is not guaranteed uh, to inherit money. But those are arguments to be made. If you have someone maybe a terminally ill parent or something like that, or maybe a terminally ill parent who can't change their will because they're incompetent to do so, or something along those lines. At what point does that sort of shift? Shift the concern, or sort of shift the debate, I suppose.
Right. So, John, is this something you start thinking about as soon as the client comes in and starts talking to you, or is this something that you start to consider a little farther down the road? I mean, I'm assuming that the client isn't coming in and that's the first thing out of their mouth, but I mean,
Right.
obviously,
I mean,
obviously, finance is a big part. So,
yeah, I mean, it is so I mean, so when a client comes in, I'd be interesting to hear what the other panelists say when we meet. But I think, yes, it is definitely one of the first things I'm thinking about. So they're coming in if they have children, or child or children. I'm thinking about that for them. Child or children, under 18. I'm thinking about sort of like, a parenting plan, that sort of thing. And then
mhm,
and then I'm obviously thinking about child support and alimony. But in terms of the property division, I'm immediately, I want to know, just off the top of my head, what do I care about the most, in no particular order. I want to know how long this marriage is, what types of assets were sort of earned during the marriage, and I want to know, what was inherited, what was inherited. Are there trusts? What has been gifted? Are there premarital assets? And I'm
sure.
looking right away to see what ought to be excluded. I don't often bring up dissipation. Um,
That's
almost
something that
not
just sort
to,
of comes out as the
it
story
usually
develops.
comes out.
Yeah.
I guess maybe I should, but I often don't want to encourage the argument because it's often not the right art. But if it comes up, I will. But certainly inherited, premarital, and trusts, I'm really looking at that sort of thing. From the beginning. Very often, people will come in. Uh, anyway, at least my clientele, reasonably educated, expecting that things will go sort of 50-50. But yeah, no, I'm looking at those. I'm looking at those three, sort of inherited, gifted, trusts,
Sure.
premarital. I'm looking at those differently, and I want to just make sure that I understand, do those deserve, do we have a credible argument to suggest that those go in a different bucket? And then I'm also obviously looking at, if I'm going to exclude those, how much am I looking to exclude versus how much else is left. So if I'm looking to exclude $2 million worth of assets, and there's another, $1 million left, that's going to look a little different than anything else. So
Right.
yeah.
Okay.
So
Um, so John, for attorneys who are listening to this episode of the podcast that don't practice family law,
yep.
what's the one piece of advice you want them to take away from this topic?
Oh, if they don't
If they're not
practice,
practicing, yeah.
yeah, if they don't practice family law, and they're in, other areas of the law. I guess it would depend on what area of the law you're in. But I would say that if you have clients, one thing they might take away is, if you have clients who are going to get married, you want to make sure that, if you can, you want to try to influence them, and um, see if you can get a premarital asset. I'm sorry, I misspoke. See if you can get a prenuptial agreement,
Hmm.
in place, for example, because of the way that our law works, and you want to make sure, if possible, that you can protect
Okay.
those assets. So that
Sure.
would be one thing. Obviously, I would hope that if you're not in this area of the law and you have such a client, you would seek one of us out.
Yeah.
Um, Yeah.
Oh, okay. So, and folks, for attorneys who are listening who are family law attorneys, we've alluded to it a couple of times now. John is leading an MCLE program on this topic. It's on June 26th. It's called Identifying and Proving When 50-50 Isn't Fair. In that program, John and the rest of the panel will be taking a 3-hour deep dive into the division of assets. Can you give us a rough preview and your pitch for why family attorneys should join?
Yeah, I mean, I think first of all, we have you know, I don't think we talked about this yet, Bruce, but we do. So
Yeah.
we have a good panel. I'm going to be on it. We have Richard Novich from Todd and Weld on it. We have Alex Jones from Brick Jones, McBrien and Hickey and Needham. And then we have Judge Christine Anthony and Judge Thomas Barber. They did it maybe last year. I don't know if the year before, but yeah, those are three, I hope, the three experienced lawyers, certainly. And then we got the judicial perspective, two very sophisticated judges who had themselves sophisticated practices before they rose to the bench. And so really we get the sort of the real world sense of how that might apply to clients. I think it's kind of a critical area of the law, and why I was kind of thinking about it as an exciting topic was because I do think, again, myself included, I do think we often default to that, and as I say, very often that might be the right result, but I think we certainly owe it to our clients to really do a deep analysis and figure out if the property division ought to be the way it often is, or whether
Right.
there are other ways. So there are other ways to sort of cut up the pie. So I think it's it's an incredibly important issue for practitioners, divorce practitioners, to sort of get around. And there's a lot of there's case law around it. There's certainly a lot of squishiness behind it. It's not exactly black and white. And it's very much the case, as is very much the case for much of this stuff. But I think it's a really important topic, and I hope I hope folks can join us.
And on that note, I will say this program, it's in person and it's online. So if you are available, come on down. I recommend coming into the building. The opportunity to get to talk to some of this faculty one-on-one, either during the break or at the end of the program, it is invaluable. This is a truly great panel of attorneys and judges here. So, folks, if you can take advantage, come down in person. Obviously, if you're hearing this after June 25th, then just know that the program's available on our website. Please feel free. It'll be available on demand for at least a year. So do check it out.
We would love to see folks in person. I know we wanted to have it in person. A lot of us just sort of missed that, that connection with the audience. So, we're available either way, but yeah, it really is nice to have some people in person. So we certainly hope that some of you can come in person at the very least.
Absolutely. So, John, I want to thank you for taking time out of your day to chat with me.
Absolutely.
Always a pleasure. And
thank you, Bruce. Likewise.
I realize the hockey season's almost over, but we've always got next year.
We've always got next year, exactly. Well,
right.
Thank you, Bruce. Thanks for having me. I much appreciate that, and we'll see you June
25th.
June 25th. Okay.
All right. Thank you very
Excellent.
much.
Take care, Bruce. Thanks a lot.
Bye.
The MCLE This Week podcast is a production of Massachusetts Continuing Legal Education in Boston, Massachusetts. For sponsorship opportunities, email us at podcast@mcle.org.